Well, welcome back to Friday, and it's TuckerAllen Live here on Facebook, as we normally do each week on Friday, and bring you something new and different as it relates to wills, trusts, estates, elder law. Today is no different, and we're going to be joined here by Kevin, TuckerAllen attorney. Welcome, Kevin.
Hi, Scott. Thank you so much for having me today.
Well, let's talk about probably what I think when I'm out and talking with people or and it comes up. And I think it's a really a confusing part of trust or will. You know, a lot of people said, well, I'm good. I had my will taken care of. No problems. And I think that could be a mistake for many. And so I think it's important. Let's talk about it. So what is really right for them? Maybe let's talk about the differences and what the negatives are and kind of clear it up because maybe it is appropriate, one or the other or both.
Sure, absolutely. So with wills, a lot of times we see that a lot of people, they kind of assume that, okay, if I have a will, then I get to avoid probate. And that's just unfortunately not the case. So a will is not a probate avoidance document. What it is more of an instruction sheet would be a good way to think of it for that probate judge. So it's just kind of telling you, or telling the probate judge what your wishes are. Whereas a trust is that probate avoidance document. And then kind of the second thing that we see pretty often is that a lot of people, they ask, okay, well, what's this like number? What's this, at what point should I go from having a will to where a trust would make sense for me? And I don't think there is really a number that makes sense to say, okay, well, you've got so many assets now, let's have a trust. I don't think that that's quite the case. I think it's up to the client. If they value avoiding probate, they don't want their loved ones to have to deal with that, then I think a trust makes perfect sense, kind of regardless of the asset number there. And another thing to think about too is that here in Missouri, whenever you go through probate, unless it is the smaller, we have two different probate courts. Most people are in the probate court that requires you to have an attorney with you, and that, there are statutory fees attached to it, and it's going to cost anywhere from 5% to 20% of your total estate. Yeah. So that's just another thing to remember.
I mean, I think it is. It's just there's so much confusion. I mean, people are ingrained, I think, as they get older, and they get to a point where even younger people, and they're in their 20s and they start getting jobs, right? I heard of a will. And I think if you break it down into maybe, let's just say, two goals. And that is one, I want my stuff to go where I want it to go. Like you said, it's an instruction sheet. But more importantly, and I think what people miss out when they just do a will, and we talked about it, I want to go into a little bit more, and that is, I don't want any more of my estate to be charged for fees, right? I don't want to have to hire a lawyer. I don't want the court involved. I don't want any of the system telling me where my stuff should go and then charge my heirs or the people I want it to go to. And that's really the focus, for someone who maybe in their 20s or 30s, and that's kind of the goal is just don't focus on where should your stuff go in the case of an event, right? And it really is that twofold step process. I mean, you can do one without the other, right? And at least it's a good start, right?
Yes, absolutely. So having that will is an excellent start. So, and with the will, there are things that you can do that will help lessen probate. You can get those transfer on death designations for some of the things that you own, such as your vehicles. You can get the payable on death designation as well for a bank account, things like that. So there are ways with the will that we can avoid some parts of probate, but with just a will by itself, it isn't really possible to totally avoid probate.
Yeah, and it's I know that we've had Teresa, TuckerAllen attorney, on, and she talks about baskets. One pouring stuff into another basket. That's the point of the will, taking things and maybe putting it into the trust basket and avoiding probate. We've heard the word probate, and that is you go get a lawyer. The lawyer's paid by statute, and then it's based on what you have, right? And it's just unnecessary. I mean, I think that's the beautiful part, right?
Yes, absolutely. So with that will that you were speaking of that pours everything into that trust basket, if you have a trust, that's the pour over will. And what it is, it's for anything that, if you forgot to title an asset over to your trust or have a POD or TOD designation to your trust, then what that pour over will does is that it picks up whatever this asset is and it dumps it into your trust. And so the trust is great in that it allows you to keep everything managed under, in one place, in that one basket that you have. That trust just allows it to all stay there. And if you do it correctly and you get everything funded into your trust, then it is completely probate avoidant.
So we've talked, I know, in the past about the things that people hear: TOD, POD, transfer on death, payable on death. Can you utilize those with a will, beneficiary deed? How do those work together?
Sure. So you absolutely can utilize those with your will. So if you just wanted to go the route of the will, then you could go to the financial institutions where you have assets, or you could go to the DMV, and you can make those designations that say, okay, whenever I pass away, I would like this to be transferred upon my death to the beneficiaries of your choosing. So there can be some issues with that. Some financial institutions, they will allow you to name multiple beneficiaries, but they won't allow you to split the percentages up as you wish. So if you name two beneficiaries, they would say, perfect, we're just going to cut this asset in half, and give one half to one beneficiary and one half to the other. Where, sometimes you might not want to do it that way. Maybe your beneficiaries are your two children, and one of them is a doctor and the other is a teacher. And so there's a gap in the income that they have, and maybe you want to provide a little bit more for that child who is the teacher, which that it just might not allow that. It doesn't allow that fine control that a trust would.
I wasn't really avoiding it, but I'm pretty good at procrastinating. I needed a trust. When I found TuckerAllen, all our questions were answered, all of our fears allayed.
You want your wishes in place, so there's no guessing, no stress on the children.
Basically, they talk about what you need, what's important to you. It was more conversational, really very simple.
Yeah, I mean, the personalization's key. When you sit down with you and kind of, lay out a strategy, and here's what I want to do. We had an aunt in the family who was very particular about certain things, and certain things going to a charity and do this. And you can be very creative in the trust. And that's the whole point of utilizing both. And they're great vehicles, on their own. It's just you're enhancing it by putting options on, the will vehicle, which is really nice. So
yes,
minor kids, obviously, what's better? Just a will trust?
With minor children, my suggestion is always going to be go the trust route, just because with that trust, it's just like you're saying, it's so much more personalized. Mm-hmm. It allows for more control, and you can set more parameters. And with minor children, you might want to do that. With a will, whenever that child is no longer a minor, once they turn 18, then they are going to be given access to all the assets. They just get it in one lump sum whenever they turn 18. Whereas with trust, you can set up those parameters and say, okay, you're not getting any of this money until you turn 25. And whenever you turn 25, instead of giving you the entire bulk, all the assets in one lump sum, we're going to give you a third of the assets whenever you're 25. And then let's say 5 years later, whenever you're 30, what we're going to do is we're going to give you half of the remaining assets. And then 5 years later, whenever you're 35, we'll give you the just remainder. So it kind of allows that control where you can break up the distributions. Whereas with a will, it's one lump sum, 18, there it is.
Yeah. And it is, we've talked again about individuals making decisions and managing your estate, or,
Mhm.
making sure in the trust you particularly choose, hey, I want this person here, I want that person to do this, and to make healthcare or financial very, again, unique. You may have unique circumstances and unique needs. And I think that's the wonderful thing about trust. And so as we round out our conversation today, we've talked about powers of attorney and healthcare. Now, those things that you must have, whether you have a will or a trust.
Yeah, with either a will or a trust, you're going to want to have those POA documents for the durable power of attorney, which is that financial document, and you're also going to want to have that healthcare power of attorney, which is, as it says, for your healthcare
Yeah.
decisions. So, especially right now, wintertime. There's still a pandemic that's going on. Those are incredibly important documents, regardless of whether you're thinking will or trust.
Yeah. So people that are watching now say, oh, I've got a will, but I don't have the POA or the healthcare, something that can be drafted and after the fact, right, and added as a supplement and enhancement to what you have right now.
Oh yeah, absolutely. If you've got the will or the trust already, but you don't have the POAs, yeah, those are something that absolutely you can get drafted as just a single document. Or if you're trying to decide between a trust and a will still, you're not sure, then still a great time to go ahead and at least take that first step and get the POAs taken care of.
Yeah, I mean, I've seen it, and I've talked about it. The results of not having those documents and the struggles that a family goes through,
Mhm.
making decisions, and then maybe disagreements. I've even had that conversation with our family that we know that there could be a disagreement, and thankfully there is a healthcare power of attorney that someone just gets to make the decision, and you don't have this fight. I mean, you may still have a disagreement, but ultimately you get to make the choice. I want John to make the decisions for me no matter what. And I've talked to John and I said, John, I don't want to be put on, artificial life support or whatever it may be. And this pandemic, we've talked about it. If you don't do it now, if not now, when are you going to do it? What is it that's going to trigger you to make that decision? Right. Because I think about when I travel, I get on a plane, or I think about, I've talked about thinking about funding my trust, but anything particularly about money and your health. If, I know someone just all of a sudden has COVID and is now sedated on a ventilator. And I'm thinking, gosh, I hope they had healthcare power of attorney, and had their finances in order. And they're young. I mean, young by, I think, mid 40s. And I'm thinking, this is not a discriminator. It's an equal opportunity disease, and it goes young to old. And so I think that's a good point, a way to end our segment today, is to talk about the addition of POAs and the healthcare POA. Really instrumental. Even if you have those, you don't have to have a will or a trust to have those, do you?
No, not at all. Those are two things that they are outside of at TuckerAllen. The way we do things is in packages, so we're always going to provide those if you are getting a will or trust package from us. But you don't have to get a will or a trust to have the POAs taken care of. And yeah, exactly as you were saying, those are such incredibly. It cannot be overstated how important those documents are.
A great example, I was just thinking as you were mentioning it, we do these POAs for college-bound kids. That is something that is really overlooked. I did it. I had 3 kids go through college, and I've got 2 more, and I didn't even think about it. We do that for kids who are going away, right? Because it's important to have their situation when they're not local and they're at distance, and you can't get there, and you have to have something in order, right?
Absolutely. No, for college students, it's something that should definitely be done, especially that financial power of attorney, especially if they're going out of state. Lots of people who go to colleges, they might live in St. Louis and they end up in college in Georgia. And then their bills are still coming to your house and nobody can take care of them because no one has that durable power of attorney. And now they're in Georgia, and it just creates a problem that's very easy to take care of with that POA. You get the POA, no issues. Whoever it is here can take care of it for them, and no worries.
Great. Well, Kevin, thanks for joining on TuckerAllen Live on this Friday, and I appreciate your input today.
Yep. Thank you so much for having me.
Well, continue to check us out every Friday. It's going to be the same time, 1 o'clock Central Time. We'll just spend about 15 minutes with you covering topics. You'll have an opportunity even next week to ask questions in the comment section. We'll try to get to those. But also check us out at TuckerAllen.com. You'll get more information, plenty of resources on there, including videos like this, our elder law podcast. We can tune in and find out more information with regards to that. And then also check out for information and watch for virtual town hall, where we can talk about where you can log in live. You have to register first for this. You log in live, ask questions, and get answers from our panel at TuckerAllen. So until next Friday, we'll see you then, same time, same location. Have a great rest of your week and weekend.